Welcome to the Digital Agency Growth Podcast. I'm your host, Dan Englander. Sharon, nice to have you back on the show.
Hey, Dan, it's great to be here with you.
Yeah, for sure. And I love having you on because I think it's good to revisit the legalese every so often, right? Because like these are the things that if you don't pay attention to them, they can come back and bite you. So there's so much to cover, and it's also changing. I think that what matters, like what's worth prioritizing, changes over time, and your risk profile changes, and you can't protect everything. So you have to kind of focus on, what areas matter the most. So to kind of bring this to a question, I'd love to just start with like, what's the IP that's worth protecting these days? Like, what is the sort of thing that you and your clients are focusing on and kind of honing in on in terms of IP?
Yeah, it's interesting. We've always counseled agencies on protecting their IP in a new business situation. Those times when you are sort of dating, but you're not selected yet. And so you're not married, and yet you're having to show a lot of your smarts and creativity to earn your spot at the table with the client. And so we've always talked about the things to do to protect your IP in those situations: non-disclosure agreements, making sure you mark your assets up carefully so that it's very clear they're your IP, et cetera. What we've seen, though, during the past 24 months as well, during the pandemic, is that a lot of agencies who, really started thinking about all the IP they create and how they could perhaps productize or monetize it so that it could be turned into more of a one-to-many situation than a work for hire sort of client commissioned type of a product. And so that brings up a whole, different set of IP opportunities and also legal due diligence you want to make sure you do. Because what we've seen agencies do really successfully is package their knowledge in a particular vertical into a digital course, or take a skill that they are really excellent with and sort of offering an ability to give an entry-level education on that in the form of either an audit or a one-time, sort of strategy session. So we've seen a lot of productization that way. And it has made agencies more interested. It warms my cold lawyer's heart to see agencies finally interested in protecting their own internal IP so that they can license it out over and over again. So that's a change I think that we've seen over the last couple of years. And it came out of agencies wanting to keep their teams busy, agencies wanting to add revenue streams to their business because perhaps their main business and accounts were slowed down. Depending on the industries they serve. And so in every crisis, there's an opportunity, as they say, and sort of wrangling your IP and taking the steps to protect it, whether it's brand, whether it's content, or whether it's transactions, is a smart thing to do for every agency.
Yeah, that's interesting. And we've definitely tried to do that. We've worked with a lot of clients that have tried to kind of like repackage what they do into a course or whatever. Definitely can be tough, but I'd love to dig into that a little bit. Like, are there any, without getting into any specifics you can, are there any stories you can tell, like any clients that you feel like have done that really well and managed to repackage their IP in other ways?
Yeah, I can. I can think of an example of an agency client of ours who focused on travel and tourism. And, obviously one of the most highly affected areas during the pandemic, in addition to food and beverage. And so, what were they going to do? And they had a successful virtual event, which was an education event and which was monetizable, where they charged for a fee. They lined up virtual speakers who were experts in the area. And some of the agency team members served as experts as well, created a faculty and branded it along with the agency. And it's an offer that's repeatable from year to year. It's also a way to highlight the skills of their team members or the experts that they collaborate with. And it's a product. It's a product separate and apart from fee-for-service work that the agency does. In another case, we've had an agency client productize systems and processes that they've created for the benefit of other agencies and sort of offer that as a white label opportunity. We're seeing an explosion in strategic alliances between agencies and white label opportunities that involve some productization. And that also has IP consequences as well. So I don't want to oversell the fact that in most cases, I haven't seen any agency sort of give up the fee for service work and just focus on the product model. But when you weave it in, and this is IP you've already generated anyhow, this is inventory you're already sitting on. When you're thoughtful about packaging it in a way that's purposeful, it's a nice additional revenue stream that can help you over some of those other rough spots. And you protect it once and you maintain those legal protections, and it's kind of a set and forget in some ways, which is, great. It's a beautiful thing for a service business.
Yeah, that makes a lot of sense and is definitely attractive. And I went through not the same process of like copywriting a course or something, but we trademarked this concept for like relationship sales at scale, which is just kind of like a lofty or like, abstract philosophy. It's more just like a term. And it's also the name of this book that I have coming out. And it took more than, I want to say, like almost a year and a half from putting in the mark with our attorney to actually like getting it done. So I don't know if it's going to be lucrative or useful. It was sort of just an experiment. It's hard for me to wrap my head around like whether there will be a payoff in terms of like legally protecting it and having gone through like the time and money of that process. So I don't have a great question. Do you have any thoughts on that? Like, what are some things that ways that could pay off if at all?
Right. Well, first I think of, there's kind of, I take a triangle approach to explaining packaging and monetizing IP for agencies or consulting firms, or you've got your brand at one point in the triangle, which is your trademark or trademarks. Sometimes there's more than one. If you've got multiple offerings or courses, you've got your content, which is subject to copyright protection, depending on how you package it. Then you have what I call transactions. It's the third point of the triangle. And that is, how are you monetizing this? How are you licensing it to people? What do those documents say? And also transactions in, and by that I mean, and a lot of agencies skip this part. Did you use freelancers or contractors who are not your employees to help you create this stuff? Because if you did, you want to make sure you own the rights to the work that they contributed to the package. So it's brand, it's content, it's transactions, trademark, copyright, and licensing in most cases. And so as to how you monetize it, it depends on how you want to distribute it. If you want to distribute it to the end user, then it usually looks like creating some sort of digital information product or digital subscription to content that people can access. If you're creating something that you want distributed as a white label product through other agencies, then that's typically a license and a distribution agreement. And that's how you monetize it. You get paid when they get paid, so to speak. So it really depends on what's appropriate for the kind of product you've created. But it tangentially not only creates some revenue for you, which can be passive, but it's a great lead generation tactic as well for agencies who want to show their smarts as a way to build authority in their target market. It's another way to give a nice access point to even a prospective client who's not ready to engage you for your full suite of services yet. So those are the examples we're seeing.
Yeah, that makes a lot of sense. And it's funny because like everybody, all of us are conducting experiments all the time and we don't know what's going to work or what's not. But so I'd love to get your thoughts on that. Like at what point, how do you know when it's time to like legally protect a process or a concept or technology or whatever it might be?
Well, I think the first barrier to that is determining what's your end goal. Is your end goal to actually monetize this as a standalone revenue source for the agency? Is your end goal to really use this to get exposure for the agency's expertise and sort of show you off in a flattering light so that the target clients who fit your avatar will find you and notice you? So what's the end goal? We start with the goal in mind. And after that, you sort of figure out what model makes the most sense for you. And if your model doesn't rely upon building this as a separate revenue stream, then perhaps you don't want to invest as much of your resources of time and energy in packaging it and the legal protections for the same. Sometimes your goal is you just want to protect your secret sauce, so because it's going to get out there, competitors are going to have access to it. You sort of want to plant your stake in the ground as the author or the creator of this school of thought, and you have to decide as an agency leader, what's that worth to you in terms of investing your time and your money. So I like to tell agencies, do an audit first. Take a look at what you have, take a look at what your end goal is, and then decide what kind of resources you're willing to devote to the legal protections for everything that you want to package.
Yeah, and you touched on something that I think is always interesting, which is secret sauce. And I'd love to dig into like where does the secret sauce actually live? Because like I've been with this business since 2014, and then selling into brands in previous lives. I've signed thousands of NDAs at this point.
Yeah.
It seems like I've yet to come across something that's like, wow, this is actually different and that's special, and that if like and rip offable in a way that would be like lucrative to somebody if they ripped it off. I think more and more we hear arguments even against ending software patents because the investment to build software is so low that it actually stifles innovation. On the other side, you hear arguments where it's like if they were to do that for pharma, nobody would develop pharmaceuticals because the costs are so high to developing this that if you can't get a protection, there's no innovation that happens. So I always hear this idea of secret sauce, and I just don't. I have my trouble wrapping my head around like where it actually lives in the agency space, especially like when so many of us are interfacing with companies that have black box algorithms. Like if you're running ads on Facebook, more and more, there's just an algorithm taking care of that. So I'd love to hear your thoughts on that, like without obviously divulging anything you can't. Like, are there any examples you can give of like, clients of yours that actually do have secret sauce and like what that might be like from a high level?
I think the secret sauce typically ends up showing itself in the recommendations that you make to your clients or the strategic insights that you provide to them, either before or after they've signed on the line that is dotted to do business with you as their agency, rather than in the tech solutions, which are the examples you sort of referenced, where in most cases, and this is highly general, in most cases, the tech solutions that agencies or digital marketers are putting together to help reach their client goals are an amalgam of on-the-shelf tools, open source tools with perhaps a little bit of customization, sometimes more than a little, but they're very hard to protect. And, I'm in your camp about, software and patents not really being a good match in terms of, you're better if you truly want to keep your tech solutions close to the vest. You need to handle that contractually and treat it like a trade secret, which is a topic I think for another day. But if you're going to be exposing the outside world to the stuff, then I think it depends on how it shows up in your work. If it is truly like a proprietary framework that you use to deliver insights to your clients, you may have some brands there to protect. You may have some content there that sort of demonstrates how you filtered the client situation through your framework. And that is worth something. And that is an asset to the company. Is it separately protectable or separately monetizable? In rare circumstances, I have to be honest. That's not really where, in those cases, what you want to do, again, is make sure the contract is your friend, whether it's an NDA up front before you're sharing some of what you do. And some agencies just take the approach that, look, we're gonna show you our strategic insights. We're gonna show you how we got there. You're gonna pay us to do that. So we're gonna pay you for you're gonna pay us for the insights, which probably isn't gonna make us whole as an agency for doing that work, but it is gonna settle the question of who owns what. If you want to take what we share with you as an insight and shop it with another agency, you paid us, you can do that. So you have to be smart, of course, about how much you expose them to, because if they, do decide to shop with your competition, you've got to make that not work to your disadvantage. But yeah, I think that when we're talking about monetizing IP to productize it and create new revenue streams, it's packaging of some things that are going to be public facing or client facing that you've put together in a way that reflects your expertise, but isn't customized to any one client or situation necessarily. So that's the dividing line, I think. Whatever insights or framework you're using to serve an individual client one-on-one, that's stuff you want to protect via the agreements that you enter into with those prospective clients or clients.
Yeah, that makes a lot of sense. And I think you've touched on a few things that might go into this, but you write and talk a lot about the idea of a common like legal toolkit that agencies should have. So can you talk about that more and just what needs to be in there?
Yeah, I think that based on our experience working with hundreds of agencies, there's definitely a set of legal tools that every agency should have. And you won't use them all every day, but you will use them all through the course of a quarter or a year. One is your master service agreement, or some version of that, whether you call it that, whether you call it a professional services agreement, a letter agreement, your contract for services. Even if you're the kind of agency that says, you know what, we do business with big enterprises or government agencies, and we have to sign their agreements. And so it's not so important to us to have our own. I don't agree with that feedback. And here's why. I think that you need a benchmark against which you will measure the things that are in a contract that a client sends your way. I also think it gives you significant leverage at the bargaining table because they know that you've thought through what is important to you from a legal perspective. And so it sets the negotiating table differently. So a master service agreement, sort of adjunct to that, maybe a short form agreement that you might want to use for small projects or short-term engagements. That just is your set of your terms and conditions. You slap it on your proposal or your estimate, and that thing together becomes the contract. So your client contracts. Every agency I know works with freelancers or independent contractors at some point or another. You need a solid written independent contractor agreement. Relying upon an email exchange back and forth or verbal understanding about scope of work and doesn't help you when it comes to settling the issue of who owns the rights to the work. Because even if you've paid a contractor, if they're not your employee and they haven't signed something in writing that says you own the work that they did, then you don't own the work that they did. And your client's going to want to own it too. So you got to keep the chain of title there. So that's that. I think that in some cases, we're seeing increased asks for guarantees on compliance with digital privacy regulations. And so sometimes you need a special agreement that addresses that. You need agency to agency agreements for those times when you are either subcontracting to another agency or you're entering into what we call a strategic alliance to serve a common client. That's something that a lot of agencies need to have in their toolkit. And then you need internally, you need something to protect the business. We call it a business protection agreement. Other firms might call it something else, but to set the rules of the road with your employees about things like IP ownership, confidentiality of your information and your client's information, non-solicitation of your clients should they leave the agency. There is a huge talent challenge right now, as I'm sure is a surprise to nobody listening to this overall, and particularly in the agency world. And so talent moves fast. And if they do, you don't want them taking your clients with you. So, and you don't want them poaching your other employees either in the process of leaving. So that's sort of your baseline of the kinds of agreements that every agency should have in their toolkit on a day-to-day basis. And then as you enter into more complex situations, depending on the type of work that you do, there are some other standards to add in, but that's kind of your baseline.
Yeah, that makes a lot of sense. And I think the non-solicitation part is huge these days. And with that, and I think you touched on a couple of these points, but I know that you talk and write a lot about trends and the sorts of things brands are asking for, which change over time. So can you talk a bit about that in terms of like an MSA negotiation? Like what are the things beyond what you've talked about that are really important on the brand side?
Right. We are seeing the one that stands out the most to me, and I'm wondering how big a surprise this comes to your listeners as, but we've got brands increasingly asking for exclusivity, first of all, in their relationships with agencies. Category exclusivity, product exclusivity, and it's sort of being a specialist or having a niche. This is the double-edged sword of it all, right? I'm a true believer in niching. It's a business philosophy I live by in my firm. And so I think it serves agencies well also. However, this is the dark side of it, which is that the more chops you have serving a particular kind of audience, the more likely they are to want you to themselves. So exclusivity, there are ways you can address it if you're requested to enter into an exclusivity agreement as part of your MSA. You can narrow it by product category. You can narrow it by region. You can attempt to narrow it to only a few specific identified competitors. There are other things you can do as well, but those are some of the common ways to approach. And we even see brands asking for exclusivity that lasts beyond the termination of the contract. So while you're working with us and for 6 months after that, or 12 months after that, you're not going to, that's another way to push back and say, no, we're not working with you. We're not exclusive to you under any circumstances. So exclusivity, data privacy compliance is a big one. As GDPR changed sort of our world a few years ago, and now CCPA leads the way in the United States in terms of data privacy responsibility. Brands are very nervous about it and increasingly trying to push as much of that responsibility onto their agency partners as they can. Agencies are a little stuck because they're the experts in the direct marketing techniques, the direct response marketing, the putting together the lookalike audiences for the digital campaigns on social media, et cetera, et cetera. And so they're being asked to be responsible. And in many cases, agencies are using third parties to help them execute some of this. And so agencies are trying to put the responsibility there. So this is something that gets talked about a lot now. And it's emerging. Yeah.
Yeah, so sorry, I didn't mean to cut you off. I was just
That's
gonna
okay.
on the exclusivity point. That was going to be my next question and point, and you almost said word for word what my experience has been, because we work we've branched out beyond agencies a little, but we work probably 90% since 2014 with agencies and marketing service companies. So it's like it's this constant catch 22 of like, you want us to be specialized, you want us to focus, you literally say that's why you're buying from us,
Right.
but you don't want us to ever work with anybody perceived to be a competitor. So it's like, well, which do you want? So that there's that. And then, the way I address it, and let me know if you think this is a good or bad way to do it. And if it's helpful to people, like, great. But people say like, hey, or do we get exclusivity? And I'll say like, look, at the end of the day, we're doing prospecting. If we get you somebody that wants to talk to you, they want to talk to you and nobody else. We don't have a lead carousel. And in that way, the campaigns are siloed. I'll say the whole spiel about the catch 22 we're in, and that's how we also get, there's a rising tide effect. We get to see trends in the industry, so it helps you in a way. And then from there, I'll say, if that's still a problem for you, then you need to define for us exactly what exclusivity means, like to a T, because agencies can say they do anything for anyone. It's gray. It's not like it's not that specialized. And then from there, we will build out a custom package for you to enjoy your exclusivity. And that usually kills it and never gets brought up again, So any thoughts on that? Yeah.
Yeah, no, I agree with that approach. And I also, I should have said this up front, but if anybody listening considers agreeing to exclusivity and some of their client relationships, and it's certainly your business decision to make, but it should come at a premium in terms of your fees and the way you structure them and what you charge for them. And you should be open about it. Look, if you are going to foreclose us as an agency from pitching our services to other companies who could benefit from our particular set of skills and industry knowledge, then if we're being taken off the market to be able to take advantage of those potential opportunities, that's worth a premium to us. Otherwise, you're kind of tying our hands here in terms of doing what we do best. So that's the other thing. You better be charging a premium for it. And I'm in favor of you not being bashful about it either, because to your point, Dan, that might end the conversation about it right there. Well, okay, well, maybe it's not as important as we thought it was. The other thing I will say is that the larger the company, particularly in the enterprise world, if that's the world you serve as an agency, the larger the company, the less likelihood that the internal stakeholders there are even talking with each other about your contract. It's probably a knee-jerk provision in their standard MSA that they want you to sign. It may or may not be important to your marketing counterparts over at the brand, or they may be more flexible about limiting it, or they may be so in love with the idea of working with you that they are willing to forego it. And then you've got procurement jumping in, trying to use it. They don't care so much about the exclusivity. They want to use the exclusivity as a mallet to get your fees packaged into the little box that will get them their procurement brownie points, because the role of procurement is to get your fees as low as possible. The role of legal is to avoid exposure and risk. And the role of marketing is obviously to achieve some business goal within the organization. So you got to make sure they're all talking to each other. And sometimes that's a way to handle exclusivity by saying, I want to talk with you all about this. What's really important? What do you really need? And maybe this isn't as necessary as you all think it is. And then sometimes they'll come back to the table and say, you're right. Let's move on. We're not going to worry about that.
Yeah, I think that's a really good point. And this might be a kind of a broad question, but the better clients you've worked with, like how are they wrangling those three parties, like marketing, procurement, legal? Like what does their process look like?
They are typically, I wish I could say that it starts this way. It typically comes to a head after a round or two of the paperwork being pushed back and forth between agency legal counsel and the brand's internal legal counsel, or sometimes their external legal counsel. So the way it has played out with clients of ours is that at some point we just say, we need to get everybody on a call. Everybody needs to get on the Zoom. Everybody needs to get on the conference call, whatever it is. And we're going to talk about the contract overall. And that's usually when you start to see evidence of the fact that they have not talked with each other at all about this. And usually sometimes they will immediately work to come to an agreement point with you on provisions that are still up in the air, including exclusivity. Sometimes they'll quickly caucus afterwards, and then you'll hear from your marketing counterpart that, yeah, this we're going to let this one go and we're going to move on that one, but this is one we can't move on. And so the agency really has to be proactive in asking for this. And it usually comes after a round or two of not getting movement on the hills that you feel are worth dying on, right? There are things that you might concede as an agency in these agreements that you don't love, but either they're not going to impact you significantly, or you're willing to live with them because you want to do business with the brand, and you don't see the risk profile being that high of that particular provision.
Yeah, I couldn't agree more. And also, like, there's the decision maker that you're working with, your main collaborator or whatever. But I found that it's very rare, for a deal to get killed by legal. It definitely happens, but I found that, like, it's not a good look. It seems like it's not a good look if you were an in-house lawyer or out-of-house counsel for you to, like, kill a deal that your client's working on. So it has to be something like really big and drastic. But I'd love to hear your experience on that.
It's true overall. I've seen legal kill one deal, and I was so surprised, and so was our client, because it was an influencer deal. And this was the MSA for our client to provide influencer marketing services, and the legal's approach to a particular issue was not reflective of how the influencer industry works at all. And they kind of infiltrated the conversation to the marketing. I think marketing in this particular case didn't have a lot of leverage internally.
Right.
And so they won the day, and actually our clients ended up stepping away from a longstanding client of theirs, which was a shock to them, which was a surprise to us, and which was the result of, I think, a lack of understanding of what the current best practices are in this particular discipline of marketing. And so that's the only time. Other than that, I would agree with you that it is generally not legal that's going to kill the deal. And procurement, they waste a lot of time, but I haven't had the personal experience of them killing a deal so far either. However, I have anecdotal evidence that does happen, just because the packages they try to put together are so overwhelmingly unfair to the small agency, either in terms of stretching payment out, or it's usually not about the fees themselves proper. It is usually about the terms and circumstances and processes under which you get paid. And they become so overwhelmingly taxing for the agency. They're putting the agencies in the position of being a bank when the agency just can't afford to do it because the account is so large. So that can sometimes do it also.
Yeah, I mean, the procurement departments seem to be the most, like, bewildering and ambiguous units for agencies or anybody else that's any vendor for that matter. And it seems like we've gotten the most questions about, like, how to deal with procurement, right? Because it's like this black box. The people that are in these positions, might not have the same, they have different incentives. Who knows, they might be less of like a career minded person than a legal person or a decision maker, on the marketing side. So how do you deal with procurement? How do you become friends with them, and how do you get what you want out of that black box?
You have to have an internal advocate in the marketing function over there who will run interference in some cases. You have to help. The best strategy I can offer is to push back on what the business justification is for what procurement is asking you to do, and ask them to justify it in front of your marketing clients. Because I can tell you again, you could be arguing at the same point with legal, procurement, or marketing, and they all want different things, even though they're raising the same point as an issue. Procurement people are incentivized by how closely they can follow the company line in terms of payment policies. They want to push your payment out as far as possible. Or if you want to get paid more quickly than that, they want to extract discounts out of you in order to get your own money for the work that you've done. So know how the game is played, first of all, understand how they're incentivized, which is they don't care so much about avoiding risk, or they don't care about competitive restrictions. They care about saving the most money and getting the best possible payment terms. And that's how they're incentivized, by the way. So, before you want to take it out personally on one of them, understand that that's the job, and that's how they're evaluated is how they function in those two areas. So you need an internal advocate who can understand the business impact that's going to have on you as an agency, and who values what you're bringing to the table for them to achieve their goals enough to sort of be your wrangler within the company. The most successful outcomes for agencies I've seen occur when that happens, when you've got somebody internally and who's your marketing client, advocate for you and team with you in terms of getting the deal through procurement.
Yeah, that makes a lot of sense. I think that's really tangible and helpful. I appreciate that. So Sharon, kind of getting towards the end of our time,
Yeah.
what do you have coming up at Legal Creative? Like, what are you working on these days over the next few months or so?
We are working on, as you and I speak, we are getting ready for a couple of conferences that we're going to be sponsoring and attending. We are evolving our legal toolkit for agencies, which is the agency protection system, by adding new tools, templates all the time. And just really focused on building out as much helpful content as we can for agencies so that they can be aware and educated in some of these areas. And of course, we're always here to answer questions as well at legalandcreative.com.
Awesome. We'll get that linked up. So Sharon, always a pleasure. And let's do it again. I think we could probably do a whole other episode on negotiations or IP or just things that have changed since we last talked. So appreciate it. And look forward to talking before long.
I'd love it. And thanks for all you do for agencies too, Dan. It's good to catch up with you.
Likewise. Yeah.